Good afternoon. This is the second panel of CPIP's IP platform supporting invention and inspiration. The theme of this one is consumer products, IP in our everyday lives. And we have quite the distinguished panel here. I think you probably want to hear from them, not from me. And so we're going to get started. I'm going to read off the four names in the order that we're expecting to hear from them. First, we have Tom Stoll. Second, we'll have Bill Coughlin. Third, Henna Neltner. And then fourth, Jim Pooley. And without more, Tom?
All right. So I should start off by saying, somebody was joking with me earlier that there's only been one panel, I think, of the whole day where everybody stayed in their same jobs. I've moved. I left Boeing. I'm working over in the ABA's IP section as their legislative consultant. And I have to say that the views that I'm expressing today are my views and not those of either Boeing or the ABA. And with that out of the way, I want to talk to you today about some of the debate we keep hearing about IP, that it's this tug of war between IP and innovation, and you can't have IP and innovation at the same time. And I think that's a short-sighted argument, I think. It kind of loses perspective of the big picture of how important IP is to our economy, our ability to innovate, and to what the consumers see in the marketplace and what we can buy in the stores and online. And that's because IP is what justifies the massive investment that companies have to make when they're going to develop a new product. Hopefully I'm preaching to the choir here, but I really, I've been working on government affairs issues for a while, and this theme of IP being bad for innovation is all I've heard for several years, and I think it's important to talk about the other side of the issue, and like I said, the big picture being it's great for consumers and for innovation. And that's because IP serves to companies as the mitigator for the risk that they expose themselves to when they invest so heavily in R&D. And let's look at this in the perspective of what it takes to develop a new product, to sell a new product. As an IP attorney, as a former IP litigator, when I was talking about products, it was usually damages, and you're calculating the lost profits based on the sale. But what I'm talking about is how much it really costs to make a product and bring it to market for the first time. And I don't think consumers get that. I think when somebody thinks about buying a product, they're talking about how much it's going to cost them out of pocket, how much is their credit card swipe going to cost them. And even Tom Stoll as a consumer was, I'm an idiot when it comes to what it costs companies to make various things. Let me just throw it out on the floor. How much does anyone know how much it costs to build to sell and make an iPhone 6? Anybody want to guess? $350. Okay, that's good. So the parts to make an iPhone 6, on my research I discovered this, it's about $200 to get all that stuff together and build an iPhone 6. But what it really costs to make an iPhone 6 depends on which one you're talking about. If you're talking about the very first one that came off the line and was the first one in the stores to be sold, serial number 1 of the iPhone 6 costs closer to $300 million. Because that's how much it cost with all the research and development that went into the technology that went into making that first item. Apple had to invest that much money in its product development to get that first iPhone made and sold. And of course, when you're talking about the millionth or the 2 millionth iPhone 6, we're getting closer to $200 per item. But that initial investment that they had to put aside to take out of their profits to persuade the directors and the shareholders to invest was closer to $130 million. Apple invests according to published reports, between $2 and $5 billion a year in R&D. And it's the IP that gives them the comfort to spend that much money, because they know if they come up with a product and they get the proper IP protections, that they can be sure that someone's not going to rip them off in the United States, making a competing product, and take a cut of that investment. They're more sure to recoup that investment, is what I'm trying to say. So I came from Boeing, and let's talk about what it costs to develop an aircraft built, a fighter or a bomber that they're going to build for the government. And who pays for that investment? Anybody know who pays for it? I saw a government contracting attorney back there. I'm going to call on him to ask who pays for the investment. that goes into building a new fighter or a new jet. Everybody knows that, right? It's the government, right? Yeah, we pay. The taxpayer pays. The government pays. So basically, the government will come up with an idea, wants to build a new aircraft, like it's going to build a new nuclear armed bomber, and it'll put out a bid, and companies will put together these offers and some designs and spend a little bit of money, and then a couple of the companies will probably be picked to build a prototype, and the government will pay for that, and you're paying for that. And then, eventually the contractor who wins the final bid, gets to build potentially several hundred of these aircraft at, hundreds of millions of dollars. And again, the government's paying for the final research and development that goes into that design. So that's the government that is assuming all the risk. And that's in the case of defense contracts. But when Boeing built commercial aircraft, it's Boeing that put together all that money. And if you go back over the years, in the 50s and 60s and 70s, even to today, the 707 was a make or break investment for them. They put aside $37 million to go off and build the first 707. And if it wasn't commercially successful, the company was gone. And it's that kind of investment that I think people have to keep in mind when we're talking about why IP is important to consumers and to the U.S. economy. The 787 is a recent example. It took 8 years for Boeing to design that technology and build the first airplane, and it cost $32 billion worth of research and investment dollars to build that first one. And I saw a quote online that says the first 787 that went to, and this is a commercial airline company, cost Boeing about $30 billion to build. So that's what I'm talking about. Not how much that last one cost, but how much that first one costs, and how you can justify that sort of investment when you work at a big company. This is real money. This isn't peanuts we're talking about here. Boeing spends about $2 billion a year. Microsoft, $10 billion a year. And even if we go back to Apple, so we're talking about consumer products, I don't think a 787 is necessarily a consumer product in the minds of most people. But putting it in that context, go back to 2005, 2004 timeframe, when Apple built the first iPhone. They spent $150 million putting that one together. And it sold for around $400. It moved around a little bit. So they had to sell more than 375,000 iPhones, the first time it sold an iPhone, to recoup the cost of just the R&D. And that doesn't account for the cost of running the business, the cost of advertising, all the rest of it. So, I'd ask the question, if Apple didn't have a strong IP portfolio, I don't know if you guys are familiar, but they have a really great design patent portfolio on the design of the iPhone that we all love. I don't know how many of us have the iPhone up here with me. They didn't have that portfolio. I'm sure they would have made the first iPhone. There's no doubt in my mind they would have taken that risk. But the question is, would they have come out with the next version and the next version? Would they have been able to secure the market share that they have today had there not been those IP protections? And would consumers now have the choice of all those products if they didn't have the IP that they have? And it's not just big business we're talking about here. Small businesses, even more so, are relying on their IP to justify their investment. If you go online, you'll see there's lots of studies that talk about how successful small companies are and how successful startups are, whether they have IP or not. And I think it's obvious. Why is it that companies who have IP are more likely to succeed? Because they can get the investment capital that they need to keep going. Because venture capitalists and other investors are more likely to feel comfortable with them if they have some IP to protect that investment. It was interesting when I was working on the Myriad case at one point in my career. It even applies to gene patenting. So if you may not be aware, but there was a race to find the sequence in the Myriad case that they discovered and that they patented. And there were companies, government grants all over the place, spending money on this research. But Myriad secured $20 million of venture capital funding. And it was that money that helped them be successful and cut short the time period it took to isolate that gene and to identify which sequence of genes were responsible for a couple forms of cancer. So I think consumers don't realize it, but they benefit from the IP system in that way too. But I think they are starting to get it. Anybody here watch Shark Tank? Yeah, all right. Yeah, I love Shark Tank. It's one of my favorite shows. What does Mr. Wonderful love to say when he's got people in front of him, other than "I love money"? His favorite quote for me is he always asks, do you have IP? And if they say they don't, he typically says, what's to stop me from spending a couple $100,000, take your idea, take all your market share, and then put you out of business and run this myself, right? It's exactly right? But it's the IP that prevents that from happening. It's the IP that protects the small businesses from allowing that to happen. There's a few of us in a coalition on trade secrets legislation. We're supporting the efforts by Congress to improve the U.S. trade secret laws. And we go up to the Hill and we talk about how important it is for the U.S. to have a strong IP regime when it comes to trade secrets. The idea being that, if a competitor takes your technology and takes it over to another country and can manufacture it for less, right? Then what happens? Well, the product that you're competing with is going to be made using your own technology, right? And so you could lose that market share, you can lose that product line, and that company is going to lose those jobs. But that IP protects that investment that the company makes in those products. So my suggestion to you is, give it some thought. Think about the bigger picture when somebody says IP is bad for consumers, IP is bad for the U.S. economy. Sure, there's some legitimate complaints to be made about patent trolls out there skimming off the top. I'm not going to argue with that at all. But I think when you step back and look at the bigger picture, the IP system, consumers are much better off with a strong IP system than they are without.
Thanks very much, Tom. Bill Coughlin, President and CEO, Ford Global Technologies. And I think you have some technology for us on the screen, is that right?
Hopefully.
Let me grab it for you. And here's your clicker if you
Cool,
want
thank
it.
you very much. Okay. Well, I'm going to talk about disruptive innovation primarily, but with touching on intellectual property rights. And I'm going to start in the past, but we are going to come back to the future. So I want to give you a new formula, a simple one. Disruptive innovation plus intellectual property rights equals freedom and wealth. You might not have thought about it quite in that way before, but let me see if I can prove it. The United States was actually founded in part upon intellectual property rights. Article 1, Section 8, most of you are familiar with it. The Congress has the power to do certain things. The first one, taxes, big surprise there. But right after post office and before raising armies, you've got intellectual property rights being part of that. And what really strikes me about this, the ability to promote science and useful arts, and it talks about the inventors and and authors the exclusive right to their respective writings and discoveries. So it creates this property right in this ethereal concept we call intellectual property. How important is that right? Well, most would know, I think, the second quote from Abraham Lincoln, but maybe not so many the first. In 1858, Abraham Lincoln said, in the world's history, certain inventions and discoveries occurred of peculiar value on account of their great efficiency in facilitating all other inventions and discoveries. Of these were the art of writing and of printing, the discovery of America, and the introduction of patent laws. That's just an awesome, and when I read that the first time, I just couldn't believe it. Is it really that important? And, Abraham Lincoln was an inventor, and, and he pointed out that, before patent laws, anyone might instantly be able to use what someone else invented. And so it gave the fuel of interest to the fire of genius. So how did it work out? Well, it really can provide freedom and wealth together. Anybody can create wealth with the ability to have an ownership stake in the inventive solutions. When you think about it, wealth no longer need to depend upon owning land or some sort of privilege. You could create wealth just from your ideas. And you've got freedom. Freedom's got to mean more than just working by the hour and moving around and giving talks at forums like this. You can lead a technical revolution and change the lives of everyone. well into the future. And my example here is Alexander Graham Bell wasn't a wealthy man. He worked with the deaf. He was a teacher of the deaf. His wife and mother were deaf. And so out of that, he created the telephone. And I dare say everyone in this room is carrying at least one telephone today with them. And, Tom was talking about Apple leading again. They're leading this revolution in the modern age of telephones. So you can leverage your ideas in a way that's not possible really to do otherwise. And over the 200 some years, this American experiment, or go back to 1600 and some for UK, the facts are in. The countries that have strong IP rights, they have very good economic competitiveness. And the ones that have weak intellectual property rights are not as strong from a competitive standpoint. So, if you eliminate all intellectual property law, really what you're doing is you're hurting literally the progress of the entire world. Now let's go back to the future. This is my favorite quote about invention. The best way to predict the future is to invent it. And I use this all the time at Ford Motor Company, telling engineers, don't worry about what Toyota, General Motors, and these other companies are doing. Let's create the future we want to see. Right? That's a lot more fun. And so, what's the future that we want? This is an article a couple of weeks ago where Hitachi has created an artificial intelligence computer that now is the boss of its warehouses. And so it's now programming the work done by humans. We normally think of humans programming robots, but that day can be coming, and maybe sooner, where they're starting to program us. Is that the future that you really want? I hope not. But I think through a combination of disruptive technologies, disruptive tools and resources and cultures combined can make a huge difference. So talking about robots, the human-friendly robots is a new thing. At Ford, we have lots and lots of robots. They're behind cages and screens to keep people safe. But the Baxter robot, you can work alongside it. It recognizes you and will work with you safely. 3D printers been around for a long time, but who would have thought that you could print a trachea? And some of the things that they're printing today is mind-boggling. Self-driving vehicles, you've seen a lot in the news, and Google and other companies, including Ford, working on this. And what I wanted to point out was, here it's in a golf cart. So the technology is getting down to a size that might actually work in a golf cart. I think you may see self-driving technology in many, many things beyond your normal cars. In the Internet of Things, this is a watch shown here at an Apple Watch like I carry here that can talk to the cars. And I think in the future my car is going to talk to my refrigerator. I don't know why, but I'm pretty sure it's going to happen. So, it just opens up a new world of possibility around, disruptive technologies. And my point is not just looking at technologies by themselves. Combining things, I think, is, a real way to not just innovate, but to really disrupt. So, Local Motors is a open source company to design cars. You don't need a big car company to design cars. You can just get a whole lot of people working together, and according to them. And but if I told you, I told anybody in the industry, months ago, that you'd be 3D printing a car, no one would believe it. So things are happening rapidly on the disruptive tool side. What I'm showing here is a combination of data, or Ford's OpenXC platform gets data from our cars, makes it usable. You can make things in Tech Shop. You can get online courses for nothing. Crowdfunding, you can get the money through Kickstarter and others, and then you can grow your company through an accelerator. So the tools that are out there today are just, is amazing. You really should be taking advantage of them. Like, are you an entrepreneur? Do you have the right stuff? You can actually tell that within minutes. At Tech Shop, we brought Tech Shop to Detroit, and frankly, we used it really successfully to drive innovation in the company. We more than doubled the number of inventions from Ford employees through a number of incentives, and this played a part of that. Accelerators, we brought Techstars to Detroit as well to work on companies solely looking at mobility. How can Ford work with startups in the right way? Shiva here with the Pit Stop thinks he can predict when cars will fail and be able to notify people in advance and get them to the right service location. But again, who's going to invest in Pit Stop if you can't back it with intellectual property? Disruptive cultures, working together environments are changing, and hard work is kind of not relevant at Netflix, for example. So the work environment's changing fairly dramatically in some places. Google, when you think of improving things, they're not thinking 10% improvements, they're 10 times, multiplying the amount of improvement. That really changes your mindset and how you approach things. And lastly, will Ford be a disruptor again? And it is our intent to change how the world moves yet again through smart mobility. And just to show you one very quick example of this, and it's electric bikes. And frankly, it was my vision to see, could Ford create a better electrically assisted bike than exists in the world today? We don't make bikes. We're not in the biking business, kind of a bold thing. But we took one of our bikes that we created by employees to Mobile World Congress, and we won the Best Product Gadget Award of the 10,000 gadgets that were at that event. And it has software with it. And so, we're using trade secret law, copyrights, patents, trademarks, licensing, all of that law combined, using it very successfully. So what Ford will do in the with e-bikes, we're still working on that. It's kind of a back to the future. That is the future of urban mobility beyond cars. It's something that we've used for 100 years. Bikes, I don't know. But it's an exciting time for Ford, and frankly, it should be an exciting time for everybody here who's got clients or the ability to, create disruptive innovation. Thank you very much.
Thank you, Bill. And now we have Hannah Naltner from Steelcase.
Thank you.
Good afternoon. I'm pleased to be with you this afternoon. And I thought the best way to start my presentation this afternoon would be to talk a little bit about Steelcase. We're here talking about consumer products, and Steelcase does make consumer products. And although many of us likely hopefully many of us are sitting in Steelcase products at work, and you probably have been for many years, I myself didn't know much about the company before I joined the company. And I have to admit that when I first started thinking about joining the company and thinking about joining it as a corporate counsel that worked primarily on intellectual property issues, I thought to myself, a chair is really just a chair, and there can't be that much intellectual property behind it, which was my mistake. The company is very innovative and works in a number of different areas. So I'd like to talk this afternoon about the investment that we make in our products and how we use intellectual property to protect those products. Steelcase is a corporation that's based in Grand Rapids, Michigan. We work with leading organizations to help create places that allow workers and teams and the enterprises that employ those teams and workers to enhance their performance. And we do that through a number of architectural solutions, furniture, and technology products and services. We've been in business for over 100 years. We're the largest manufacturer in the contract furniture market, which you might be more familiar with as just the office furniture market. We do roughly $3 billion a year in business. And we have a global footprint with business centers in the Americas, and manufacturing centers, I should add, in the Americas, in Asia, and in Europe. We have a number of brands, which I just thought I'd highlight for you here. Steelcase, obviously, is the brand that we use in the office space, but we also use our Steelcase brand to service clients in the education space and the healthcare space. Coalesce is our high-end, beautiful design product brand that we use for office spaces and occasionally home. And then Turnstone, the Turnstone brand is my favorite brand. It's a brand that focuses primarily on small businesses. And interestingly, we're seeing a lot of interest in the Turnstone brand products recently from large corporations that have small groups within those corporations that are trying to maintain more of a startup culture and a small business culture even within their large organizations. So Steelcase strives to unlock human promise by creating great experiences wherever work happens. And we've done this over the years through a variety of products. And I apologize because I've included some pictures here that may be small for the folks in the back. But I started with pictures on the left of products that we introduced in our early days. And as you work to the right, you'll see products that we've introduced as recently as this year. We have a legacy of innovation at the company. We rely on a process that we term an insight-led innovation process, which includes developing deep insights around work, workers, and workplaces. We primarily do that through observational research as well as partnering with design thinking organizations and research institutions. We then take those insights and develop a point of view around a particular aspect of the future of work. And then we explore emerging challenges in that future landscape. So, to make a little bit more sense of that process, I've included an example here. We set out to design a new task chair, which is the type of chair that primarily you sit in the office space. And we went out and did a global posture study. We talked with over 2,000 people and observed them in their workspaces in 11 countries. And what we found was that work has changed, and people are now working in postures that might be considered more informal. I actually noticed as I was putting some of these slides together that a number of the pictures have people with their feet up on furniture, which I think is something that you wouldn't have seen 50 or 60 years ago. So we started seeing that some of the behavioral characteristics of how work is happening were changing. We also realized that the introduction of various devices, tablets, phones, was causing people to sit in different ways in their chairs. And the company came back, put together those observations, and determined that there are actually 9 new postures that individuals were using during the course of a workday. So we set out to design a chair that would help support movement through the day, movement between those 9 new postures. So for example, and this is the gesture chair here on the right, the gesture chair allows an individual to have his or her arms supported while texting or messaging. It also allows a user to recline in the chair and have a fully supported back while you are holding a device in front of your face and scrolling through content. Postures that we might not have seen before the introduction of those devices. This type of innovation, we believe, adds productivity for our customers. So we have a legacy of innovation. We also have a legacy of protecting our innovation with intellectual property. In 1914, we received our first patent on a fireproof steel wastebasket, which is pictured at the upper left here. Perhaps this doesn't seem remarkable to many of us today, but at the time it was a major improvement in the office workplace. Since then, we've been granted more than 1,700 patents worldwide. That may be less patents than some of my fellow panelists here on stage, the Boeings and the Fords of the world, but it's a number of patents, it's a significant number in our industry. It's actually more than any of our competitors, and it's an adequate number for us to be able to protect the innovation that's gone into a number of our products. We typically protect our products by filing both trademarks and utility and design patents, both domestically and worldwide. Each of the products featured here, actually including the steel wastebasket, is protected by one or more patent filings. So in the left-hand corner, if you can see it, there's a group of people sitting around in white and orange chairs. That's our Kobe chair. That Kobe chair is protected both by design patents and a number of utility patents around the innovative two-shot flexible back frame. This is actually one of my favorite chairs. It's fairly comfortable up to 5 p.m., after 5 p.m., through the whole day. We have node chairs and think chairs, gesture chairs, via architectural wall, and the two products in the upper right-hand corner are products that we've introduced earlier this year. The Brody Work Lounge, like I mentioned, more informal postures, and the Thread electrical solution. So I want to talk about the gesture chair because that's the product we started the presentation with, and just talk a little bit more about how we actually go about thinking about what type of intellectual property we need. So the gesture chair, like I mentioned, was introduced to help support these new postures that are associated with new behaviors and new technologies. We therefore have filings that are directed toward the arms and the way that the arms move, the back, the lumbar support. We also have filings that are directed toward the chair controls and the upholstery method. Design is an important aspect of our business. On the left, you can see a standard, what we call a standard back, and in the middle, a wrap back, two different design features. So we have utility claims that are directed toward the upholstery methods for both of these chairs. We filed dozens of domestic utility applications on this product. We filed dozens of domestic design applications on this product as well, and we're seeking utility protection in over a dozen countries. We base our filing strategy on projected sales, manufacturing considerations, and a number of other factors. So it's premature here because we've only just started getting patents awarded here in the United States for gesture, but I think it is worth noting, especially in light of some of the use it or lose it criticisms of the US patent systems, that we do take a very active role in evaluating our intellectual property when it comes to maintenance fees. We regularly review our patents down to a claim level and determine what may be useful to us now or in the future. So this is a similar slide to the one I presented just a moment ago. So I've talked about how we think about IP, but I also want to talk about why we invest in IP. IP allows us to protect our investment, similar to what Tom spoke to in his presentation. With the gesture chair, again, the example we've been talking about, protecting our intellectual property allows us to be able to stop other entities from copying the design and engineering advancements that go into that type of product. It allows us to be able to devote engineering resources, design resources, manufacturing resources, sales and marketing resources to opportunities that we see in the marketplace. So we saw opportunity with the posture study, and we were able to come in and create a product that actually has the potential to help individuals enhance their performance. Consider the productivity increase that may be associated with more effective or efficient messaging in an office space today. Intellectual property also allows us to protect our innovation in a way that allows our employees to earn a living and allows us to return value to our stockholders. In our industry, it is relatively easy to reverse engineer and create copying products. I would say, thankfully, that many of the competitors in our industry are very respectful of intellectual property. If we include something in one of our patent filings, it is unlikely that many of our major domestic competitors are likely to create a copying product. Unfortunately, though, we do have some competitors that are not as likely to respect IP. I was at an overseas trade show earlier within the last year, and of the products that I've included here on the screen, we saw products that were what we affectionately refer to as inspired by our products. For each of the products that are included in the 5 pictures below, and I'd point out that the two images that I have grayed out on the right weren't yet introduced. So intellectual property is one of the ways, it's in fact the primary way that we are able to protect our investment. And it's my opinion that if we didn't have intellectual property, we would not be able to devote the same number of resources to creating new and innovative products. So I'm almost out of time, and I just want to highlight a few other things. That's our sort of a rough outline of how we use intellectual property to protect our innovation. But there are other models out there, and it's worth having a discussion about those. Tesla earlier this year, in the last year or so, made headlines by announcing that they were going to open up their, I believe their full patent portfolio as it related to their electric cars. And my former employer, Toyota, announced shortly thereafter that they were going to open up a portion of their patent portfolio for fuel cell vehicles to individuals that wanted to use those in good faith. So I've been challenged by some of my colleagues internally, and they've asked me why we can't be more like Tesla. So, as I tell them, I always reserve the right to further supplement my answer. But I've pointed out that the market for electric vehicles is actually quite different than the market for office furniture. We're a much more established market, and now as an outsider to the automotive industry, I see the electric car market as one that might actually benefit from an expansion in size, and I think Tesla spoke to that a little bit in some of its press releases, that might benefit from a common technology platform, and that might benefit from additional providers. Further, I think presumably it would benefit from having additional vendors and supply chain partners. The market may grow more rapidly for them if there are additional entrants to the market. In our case, though, it's the innovative products that we alone can provide that allow us to distinguish ourselves in an already populated market. That said, Steelcase does continue to look at ways that we can foster a more fully innovative environment internally. We're experimenting with employee innovation competitions. We have a strong history of collaborating with outside partners. We're working independently to identify startups that might be good partners for us right now, and we're also working with a consortium of corporations based in West Michigan to fund an accelerator in the Internet of Things space, which I'm going to plug here briefly, the Seamless Accelerator. We have our first class started right now, and we're looking to start a second class in the spring. So if any of your clients or students are interested, we'd, of course, be interested in seeing your applications. But using the accelerator as an example, even when we don't or won't end up with ownership rights, we're still interested in what the intellectual property portfolio or the potential for the portfolio of that. We're still interested in what the accelerator participants can bring. I read recently that 40% of startups have IP and 80% of startups that receive venture funding have IP. So we, like venture capitalists, see intellectual property as some measure of whether or not that venture will succeed. I think my time is pretty close to up here, so I'll just conclude by saying that from Steelcase's perspective, flourishing communities require productive workplaces and communities. Steelcase has invested hundreds of thousands of hours and millions of dollars in creating places that allow for an enhancement in performance for teams and people. And we're still in business 100 years later because our customers see the value in that innovation, and it's intellectual property that's allowed us to protect the innovation. Thank you.
Thank you, Anna. Our next speaker is Jim Pooley. He spent 35 plus years in Silicon Valley practicing law, teaching it, writing about it. Took a 5-year tour of duty to run the intellectual patent system, and has now returned to Silicon Valley to practice and teach and write and advise. Jim?
Thanks. Thank you. Is there anybody here who owns a VW diesel? Come on, admit it. It wasn't your fault. No? Nobody? Okay. Well, you probably have friends or family that do, and they're very, very upset. It's an example of one of the ways that secrecy gets into consumer products, perhaps in a way that we might care to rethink about a little bit. So I'm going to ask you to hold that thought for a while. We'll get back to it. There are consumer interests. There are certainly public policy issues around how we treat secrecy. But the major point is we've been talking here so far mainly about patents as a form of IP. There is another form that protects innovation, secrecy, and that's one of the things I'm going to be focusing on. It's wonderful to be here, I have to say, with Boeing and Ford and Steelcase, some of our most important customers at the PCT. But I think they all participate in a process that uses patents where they are appropriate and also heavily relies on secrecy. But all of this starts with something we need to pause and consider, because the companies that produce these products are not the same companies that existed 40 years ago. 40 years ago, 20% of the value of publicly traded companies was represented by intangible property. Now, that number is 87% in just 40 years. That's breathtakingly fast when you consider fundamental changes that have happened in the industrial landscape in the past. And studies have demonstrated, most recently a study by the National Science Foundation and the Census Bureau, that among industries that are specifically very R&D intensive, like these, secrecy is valued at a level more than twice as high as invention patents, which doesn't mean that invention patents are not valuable, but secrets are. And another important lesson that comes out from looking at all of this is that intellectual property then is part of something much broader, which I try to focus on a lot, which is information asset management. That is what companies do when they develop information, they create innovation, and then try to bring products to the market based on all of that effort. So I think the theme here that we're using is actually a very good way to look at how things get done that deliver to all of us. But it's even broader than the interrelationship of the various forms of intellectual property. Information asset management depends in part on intellectual property, in part on security, in part on commercialization processes, in part on talent management, and we can go on and on. But I do want to make sure that message doesn't get lost, and I'll be emphasizing a little bit later. Secrecy is actually a form of intellectual property, deserves to be recognized. It is not, and the reason it gets shunted to the side often, it is not a registered right. You don't get it from government. Government just guarantees you the right to get enforcement of a promise of confidentiality that you enter into with somebody else, like an employee, a partner, a customer that you are collaborating with or employing in order to get something done. And that promise of confidentiality is worthwhile only because the government will stand by and enforce it. It is complementary to the patent system in ways that are very important, primarily because given the fact that most of the world does not have a grace period, all patents have to start out their life as trade secrets, and we have to treat them very carefully. And I know that one of the reasons at WIPO we had two different layers of security in our building was because every year we took in 200,000 trade secrets in the form of unpublished patent applications. We've used Apple as an example here of a company that employs a lot of various kinds of IP rights, and they do have wonderful invention patents, design patents, they copyright their software, and we know about their fabulous brands. They also care a lot about secrecy, both in their manufacturing process and in protecting information about even what the feature set is going to be on their products, which is why they were so concerned when an unannounced iPhone 4 got left in a bar in Silicon Valley a few years ago. And then we're even more upset when a year later the same thing happened in a different bar with the unannounced iPhone 5. So these things happen, and it's one of the reasons why we have to manage them. But from a policy perspective, we've always had a little bit of a feeling that there is tension between the government, as Bill pointed out, based on the Constitution, promoting a system of patenting that is directed towards public disclosure and teaching the public about what it is that has been discovered, and at the same time running a separate system, albeit mostly through the states, that enforces secrecy. Fortunately, this question has been answered for us back in 1974 by the Supreme Court, the Kawani decision, which said, look, we've had these systems run in parallel for a long, long time. There isn't anything inherently disruptive about having a secrecy system run with a patent system. The disclosure that's supposed to happen as part of the patent system is a quid pro quo for the quasi-monopoly right that is granted. It's something we do, we trade with the inventor. We don't necessarily feel that disclosure of everything that companies do is the right thing. So we can have a trade secret system alongside. Now, secrecy has become all of a sudden, I mean, years ago, it was lonely being a trade secret lawyer and even lonelier trying to teach about it. Now, everybody's enamored of secrecy because of the headlines. Cyber attacks, firms are concerned about information governance. How is it that they're going to avoid liability? Secrecy is on the uptick in terms of a choice being made by companies that are looking at what form of IP to use, in part because of the American Invents Act, which has relieved a large amount of the anxiety that people used to feel about going the trade secret route. One of those was the obligation to disclose the best mode and whether you were getting it right. Now, best mode is basically, it's in a coma. It may as well be dead. We don't have to worry about it. The secret prior art issues arguably are gone, and we even have some guarantees of a problem that never really came up that often in the past around prior user rights. So feel free to use trade secrets. At the same time, as everybody in this room knows, there's been at least a strong perception that patents are under attack and in certain ways are less available on the registration side and are perhaps less enforceable as well. And so this has caused many companies to conclude that in the intellectual property space, there is less certainty around patenting, and that so they should therefore take another look at the calculus that goes into their decision about whether or not to use patents or trade secrets. So I just want to comment on one thing that Tom has raised already. Among the issues that are current where trade secrets are concerned is a proposal now present in Congress called the Defend Trade Secrets Act to amend the Economic Espionage Act to allow a civil cause of action. Now, maybe many of you weren't aware that there wasn't one available at the federal level, but the fact is that because trade secrets grew up at the common law and were enforced at the state court level, it wasn't until 1996 that we had any federal law that punished the taking, the misappropriation of a trade secret. And with the passage of the Economic Espionage Act, we have that, but it's a criminal law only. Since 1996, there have been calls to provide an option for a civil remedy so that companies, rather than have to rely on the prosecutor to take an interest in their case, can go to court themselves and get remedies, particularly in this modern economy in which secrets can move so quickly across borders, or getting someone can get on an airplane and get out of here. Why shouldn't we rely on a prosecutor? I'll just tell you one quick story. About 10 years ago, in the heyday of the EEA, and when we were told that every district across the country had U.S. attorneys in them that were enthusiastic about going after these cases, I had a client who came to me with a story about his partner having threatened to take the information that they held together as a trade secret and publish it unless he did what what this guy wanted him to do. I can't remember what it was, but it was flat out threatened misappropriation. And to emphasize his point, he placed a gun on the table. Okay, it's a similar story to the one we heard earlier, but for a different purpose. And so I thought to myself, this is amazing. I've never had a case that was so well prepared for the criminal prosecutor to take. I called the guy in the relevant district, which was not Silicon Valley, described to him the thing, wound it up to the point about the gun being put on the table, and there was a moment of silence after, because I was waiting for him to express his enthusiasm about taking on this case, and he said to me, have you considered your civil remedies? So, no, it's not again, just because you have a decent case doesn't mean that the prosecutor is going to take it. We need this choice. The Defend Trade Secrets Act is simple, it's straightforward. It is based on the Uniform Trade Secrets Act. It does provide for a very narrow seizure remedy that will allow federal courts, frankly, as part of their Rule 65 existing powers, to order certain property seized so that it can't leave the jurisdiction and can be protected, and there are provisions for encrypting it and other things that will make sure that it's safe. This statute has exceedingly broad support, astonishingly broad support, considering what Congress is now. There are equal numbers of members of Congress and senators as sponsors on both sides of the aisle. There was only one source of opposition because, of course, industry thinks this is a great idea, and it comes from a group of law professors. Okay, they question the value of this, and they are fearful about the cost. They look at the possibility that a stronger trade secret law will mean more problems in the public getting access to information. They worry about mobility of labor. Enforcing trade secret laws will tend to intimidate employees and make them less likely to move. And they worry about treating trade secrets as a property right, assuming that there is harm when it's been stolen, when it actually is not a property right at all. I've tried to point out to them that you can buy it and sell it, it gets taxed, the government has to answer for taking it, just like any other property under the Fifth Amendment, but that's one of those practical arguments that doesn't seem to get anywhere. Recently, there has been an article called Here Come the Trolls that has added a final level of argument to this that I find particularly disturbing, suggesting that strong trade secret rights will encourage people to file lawsuits that wouldn't otherwise have been filed against poor, unsuspecting, particularly smaller companies, startups, in much the same way that we see these things happening with patents these days. And all I can say is the nature of the trade secret right, which, as I pointed out earlier, depends on the existence of a confidential relationship, means that trade secret rights operate only against certain classes, narrow classes of people. They do not operate against the world like patents do. It is very hard to imagine, in fact, I would assert it's impossible to imagine how it is that any new class of trolls would develop from making this federal option available. And so what I would like to suggest is that when we are considering the Defend Trade Secrets Act and other uses of federal law to enforce trade secret rights as well as any other intellectual property rights, it is very important to consider issues of public policy, consumer interests, employee interests, but we have to be very, very careful to make sure that our arguments are supported by evidence. In this particular case, I think we're dealing with a tool that companies like the ones you see up here use every day, have used for 150 years in the trade secret jurisprudence in the US, and need to continue to use in a modern environment where the risk of loss is much, much higher than it has been in the past. Thank you very much.
Thank you, Jim. Now, we have about 25 minutes left, and here is what I propose. Anyone who is willing to promise to ask a short question, to state the question in a loud and clear voice so that your fellow attendees and the panelists can hear you, should feel free to raise their hand, and I'll call on someone to ask a question. As a bonus, you will get to choose who is the first person to respond to your question, while the others, of course, will be free to follow up. Does anyone offer to accept my offer? Questions? Anyone? In the back.
For Mr. Pooley, and I graduated from George Mason Law School, so I'm glad to be here. I haven't been back in a long time, but I wanted to be here for this conference. My question, and I'm very happy to hear about this Defend Trade Secrets Act, because I talk about the Economic Espionage Act in front of engineers all the time. But I recently had a situation with a client whose hard drive was stolen. He's a he actually supports musicians. He's a music producer. Trying to determine the value of the hard drive that was stolen was going to make a difference between whether or not he wanted to pursue a criminal case against somebody who had been in his employ for many years. So there was a fiduciary relationship. This person was a key employee who had access to information that no one else had, so he met the threshold of it being a fiduciary relationship, and he did try to keep the information secret. Would this Defend Trade Secrets Act help him? Because the value, and from a criminal perspective, the value of the hard drive was maybe $150. The content, in terms of the music that was on there, is potential value. So in terms of, would this act help people in this particular circumstance come up with some sort of damage remedy in articulating, or help them articulate the value of things from an espionage perspective? Thanks.
Okay. Well, the Economic Espionage Act itself has been amended to allow proof of loss to be determined by the investment in the development of the information. So the answer is nominally yes. But he probably wouldn't want necessarily to go to the prosecutor to handle that. Prosecutor might not be interested in it because of it might not have all the sizzle. So having the civil remedy available as an alternative, assuming that he had good reason to want to go to federal court as opposed to a state court to get this, would certainly give him an advantage. But the major advantage in cases in the civil cases of trade secret are those where you feel that the information may escape the jurisdiction, or you need to have a trier of fact that understands better how to handle international cases and to apply conflict of law rules and all those sorts of things. So he might be better off in state court if it's a local thing. If it's interstate or international, it would be great if he had the federal option.
Hi. Really enjoyed the presentations. Thank you. I'd like to ask all of you, based on your experience at companies currently or in the past that either own extensive patent portfolios and or license patents for your products, to react to what we hear sometime in the public policy debate, that in fact patents are more of an impediment to innovation than a promoter of innovation. Is that your experience?
Hannah, would you like to start?
Sure. Thanks for the question. No, that is not my experience. We rely on our ability to protect. So, to Jim's point, trade secrets are a part of our strategy, but we rely on patents to protect product, and in our market, product is not replaced every 6 months. It's not a cell phone that you have that you replace when the new model comes out. Furniture may stay someplace for many years, and so having the ability to protect it really allows us to continue to innovate, and is certainly no impediment.
Well, you know, I think most producing companies are sane, and you know, we know that if the day can come where we're going to be infringing somebody else's right that's out there, and so at Ford we have a kind of a simple approach on licensing, that we want to treat people like we want to be treated if we're standing in their shoes, and it helps us, grounds us in terms of being reasonable with everybody, because we want people to be reasonable with us. We don't want people stealing our stuff, and we don't want to be stealing things from others. But smart companies will do have creative programs, and so talking about the electric vehicles that we announced earlier this year, that we're not giving away our patents on electric vehicles, but the door is open. We're happy to license people, anybody, under reasonable terms and conditions. Doesn't matter where you're from, an arch competitor or a new secret, scary competitor, upstart, doesn't matter to us. And so I think most companies are pretty responsible about how they work with intellectual property, and most are seeing the light that licensing is the way to go, that just holding it so close, that you could never be licensed, is not really a good thing for anybody. There could be times when you can't license, but look at the Apple Samsung situation. It's going to end up in a license. Most of the litigations end up in a license. So why spend all the time on lawyers and just get to the point of what's the reasonable amount people should pay?
Well, so I'm not at Boeing anymore, so I have to be careful what I say, because, but what we were talking about, we were sort of out of the patent reform discussion when I was at Boeing. We didn't really take a position on it, and I think that's primarily because a lot of companies like Boeing, they're going to file a lot of patent applications, they're going to get a lot of patents, and they're going to hold on to them and try to make a better product. And if somebody comes after them, they're going to have their patent portfolio available to them to sort of make the whole situation go away. But we're not in the commercial. We were not in when I was at Boeing. Our product was different. It's an aircraft, a satellite, something like that. It's not something that consumers and your typical troll is going to come after. And obviously, we're involved in the cell phone war. So. It was more of a defensive posturing to get a pretty strong patent portfolio for Boeing, if it ever needed it.
So you're saying, Tom, that there's nowhere in this country I can get a knockoff 787 on the street?
Maybe a little one.
Yeah.
Jim?
Let me try to channel some of my friends in Silicon Valley on this question, which is a question we hear a lot and certainly animates the public policy debate. There's something to it. I mean, if you ask software engineers, how useful is the patent system to you, or someone who has a pure software play, I mean, they'll say, it is mostly a problem that I worry about. I certainly would develop software because it's cool, or because I can make some money building a company around a cool new product. The patent system is irrelevant to me, except it's broken glass in the road. And of course, if you go to talk to somebody in the pharma or chemical industries, they will not have anything like the same kind of reaction. It's existential that they have patents. Now, when you get to the question, what kind of system should we have? There are those who have suggested we should have a different kind of system for software and for pharma, for example. We should have different periods of exclusivity or other variations on the nature of the right. We have, since the time we established our system, had a unitary patent system, one size fits all. And I think the way that things have rolled out as we've moved away from a traditionally agricultural and manufacturing economy, and into products that are built on software or intensely complex and that change very frequently, we've seen a lot of tension around that. But I think the answer at the end of the day is we have to learn how to live with that, because the alternative of a non-unitary system will be spending so much energy and time and effort arguing about where the boundaries are, particularly in an era where we have so many industries that cross over these boundaries, bioinformatics, for example, and there's more and more of that happening. How do we develop a system that continuously shifts to, create something where the incentive is precisely tuned to the business models of that particular industry? I think it's way too hard to do. We should instead try to make this system work the best that we can and try to make it as transparent, pull all the inefficiencies out of the enforcement process that we possibly can, and then it should more or less work, perhaps less well for some than for others, but looked at, as I think this discussion has demonstrated, looked at overall, I don't think there's any question that the patent system is exceedingly important, not just for very large companies, but to provide breathing room for small companies as they attempt to raise money and develop their products and establish markets.
So I've recently heard some arguments from people who are likely to be more skeptical about the intellectual property system than folks on the panel or in the audience, that there exists a problem with notice failure in the patent system, and that is creating challenges for innovators because they don't have timely and sufficient notice of potentially existing patent claims. Do you feel that that's an issue at all? And if so, are there best practices that you recommend or that you follow internally to minimize those sorts of risks in your own businesses?
Not been a problem for us. Anytime the public affairs group at Ford announces something that we're working on, I get a letter from somebody who says, you ought to know that we have these rights. Okay, well, fine, let's take a look and see if we need to take a license or avoid it. At Ford, we actually have it's a formal policy. We cannot infringe people's legitimate intellectual property rights. So, we have to avoid it, work around it, get a license, try to kill it if it's not a good right. But, you know, with a car, there's like 5,000 parts on a car. I can't clear 5,000 parts on every car that we make. It's not even close. So, you know, I don't worry about it. I don't lose sleep. You know, am I going to get a charge for infringement? Well, probably on some new product that we're bringing out. But frankly, we do the best job we can at trying to avoid infringement, paying people when we should be paying people. And it's worked out really, really well for us. And so, you know, it's so far for us not a problem.
Hannah, anything to add?
Yeah, I'd echo that. I think we do a fair amount of due diligence before we introduce products. And so we do a lot of clearance work, and we haven't had any, we have not had significant trouble with notice failure. It may be that our development cycle is long enough that we're able to, for the most part, to the extent that patents are being published, we're able to actually stay ahead of what competitors are doing. My experience in private practice is that some other industries perhaps don't spend as much time doing clearance work as our industry does. So that may be something unique to our industry or may not, but it's not something that we're particularly troubled about, I don't think, and we do invest a significant amount of time and energy into making sure we have clearance work done before we launch product.
As I said before, you know, when I was at Boeing, we didn't have a patent troll problem, so we weren't raising the vaguest concerns you hear from some of the people dealing on the internet side of business or software.
I'd just like to talk about notice failure from a different perspective, which is the failure of the patent system to deliver to the public notice of all of the wonderful information that it is supposed to provide. It's supposed to get across the state of the art. And this disclosure is supposed to be real and robust. So I want to just two aspects of that. You know, since the beginning of most modern patent systems, there have been inventors who have been trying to game the system by writing patents that didn't fairly disclose what they were working on or misled people and used language that was too vague to allow anybody other than them to build what they had described. So that's not new. And that, however, can be addressed and is being addressed by the authorities, including the USPTO here, in their focus on Section 112 and the obligation of disclosure and the quality of disclosure that's supposed to come out. We have to continue to work on that as a management issue. The other issue, and it's one that I often heard about in Geneva because it was voiced by developing countries who, in articulating their concerns about the intellectual property system, would say, you know, you guys talk about how wonderful this is for the world, but the fact is, all these issued patents, how in the heck are we supposed to extract useful information from all of that mass of data? And so we do have a challenge there, but it's one that I think we can meet. It's certainly one that really good technology can attack, and we ought to be able, through a combination of government and private resources, to deliver to the world a readily accessible, easy-to-use tool to understand what it is that is actually being disclosed by all of these patents in a way that mere mortals can operate. So that's a challenge, and I think there are a number of people who are interested in this. I think Google is one of them. Obviously, it's part of their mission. And we'll probably get there. And so the problem, and it's a real problem, will improve.
Down here in front.
My question's for Bill. The licensing story you tell is fantastic. I'm a patent professor. So the licensing story is lovely, and it's what I tell my patent students. This is great. Licensing is wonderful. But I remember a couple years ago, I was at a conference in some corporate counsel was on the panel, and she said, a licensing invitation is something to ignore. I'm actually not going to bring it to anyone until it becomes a complaint. Now, is that something you've seen or experienced? Is it anything that's really going on?
Well, I do know of companies that try to keep their head down, and, you know, this is the only second letter that we got from this, you know, patent holder, whatever. We don't take that approach, and we aren't be seen, you know, as a great company, and people will disagree with us, you know, on occasion, and, you know, the only problems we've really had were the kind of the nutcases out there of, you know, patent holders who are just, they just don't get it. We're not infringing this thing, and no matter what we say or do, until a judge rules we don't infringe, they're just going to keep trying to win that big lotto ticket. But, you know, licensing is a great business strategy for any company out there. We're a little unusual in that the intellectual property team at Ford gets to reinvest some of the money that we make from licensing, and we do make money from licensing, and into creating new inventions. And it's worked out fabulously. It was very difficult to get approval for that program, as you might imagine, going to the finance people whose job it is in the world to say no, to allow a mere patent attorney group to have some money to invest from the money they're making. But I said, if you know, we can create a business doing this, and a good business, and can help our industry and everybody else. And it's worked out precisely that way. And so, you know, I encourage people to dip that toe in the licensing, you know, water. And, you know, when I get a letter in, you know, oftentimes I'll try to, you know, call them up, you know, are you going to be reasonable, or are you just going to, you know, you've got stars in your eyes, and you know, you've already spent the money in your mind. Because if you're going to be reasonable, and we are potentially infringing, well, we'll deal with that. I mean, we want to be fair with people.
Yeah, I guess I would just say my experience has been that we react in some way to a letter or communication fairly rapidly. It would be not in line, like Bill has mentioned, with respect to Ford, with our values to do otherwise. So there's certainly no sitting on things and hoping that they go away, or that you just don't hear back, or waiting until you do hear again.
Tom?
I
Jim?
wasn't part of
Yes.
that process.
Yeah. Other questions? Right over here.
My question is primarily for Mr. Pooley. Given the fact that trade secrets potentially can last forever, what would you say to people who are concerned that stronger trade secret protection would actually stifle innovation?
Well, I would say primarily, first of all, what the Supreme Court said in Kiwani. Trade secrets relative to the patent right, which is an exclusionary right, are exceedingly weak, because the secret lasts, or the value of the secret lasts, only so long as someone else hasn't independently discovered it. You have no right to keep anyone else from reverse engineering your product that might contain the secret. You have no right, certainly, to keep anyone from independently developing it. And given the fact that most discoveries are made in tandem with others, people are working on the same things, that's a very, very substantial risk. And so in the real world, and particularly in the manufacturing world, secrets relative to products are often turned into either products that completely disclose the secret, where the competitive advantage is taken by market positioning, or through patenting, and the trade secret goes away when the patent is published. And so, in fact, the trade secret right, although very, very strong for in certain cases where the information has been shared and you want to stop someone and they should be stopped from doing it, inherently is a weak right, because even that person, as well as everyone else in the world, has the right to discover it themselves. So getting stronger trade secret laws really is about giving those who have this confidential relationship more of a guarantee that they'll be able to enforce it as they expected it to be in the first place. And again, as the court said there, the whole reason that these laws developed at the common law was to enforce that aspect of commercial morality. And it's essentially a moral question. Shouldn't we, if a piece of secret information is disclosed in confidence, shouldn't the courts be able to intervene to enforce that? So,
Anyone else?
Yeah, I just want to jump in real quick. You have to trace the secret from company A to company B. So there's none of this risk of trolling. And it kind of feels like a catch-22. If you patent it, that stifles innovation. If you keep it a trade secret and don't disclose it to anybody and keep it in-house, but they can independently innovate and discover it themselves, that stifles innovation. On the trade secret side, there's just no question. With the requirements of what you have to prove, there's no innovation stifling. People aren't going to be out there trolling on trade secret rights for all the reasons that Jim articulated.
Bill or Hannah, anything to add? Well, alas, we are out of time. My guess is you can rush the stage if you like, or plan for dinner. Thank you all very much, and thanks to the panel.